Welcome to the Deep Dive, where we tear through the source material so you can walk away well-informed, fast.
Hello.
Today, we're dissecting a critical, brand-new Supreme Court ruling. This one was just decided on February 26, 2025.
And this case really tells you definitively whether your company's paperwork is a real legal shield or, just a piece of paper the courts can ignore.
This deep dive is absolutely crucial for any business owner, manager, or frankly, any employee who deals with affiliated companies.
Subsidiaries, complex internal structures, all of that. We are plunging into Dewberry Group, Inc., the Dewberry Engineers, Inc.
So our mission today is to understand how corporate separateness, that foundational concept in American law, how it stands up when a bad actor uses it to dodge a massive financial penalty.
And the stakes here were enormous.
Right. So Dewberry Engineers sued Dewberry Group for, and this is key, willful, intentional trademark infringement.
They won. The group was liable. And the penalty the engineers wanted was the disgorgement of the defendant's profits.
Which just means they wanted to claw back all the money the wrongdoer made from the infringement.
But here's the hook. The infringing company, the group, reported operating at a loss for decades.
Well, its related companies, its affiliates, made nearly $43 million in profits.
Exactly. From the very same enterprise. So the lower court said, forget the formalities, we see one enterprise, and you owe $43 million.
That ruling prioritized, economic reality over corporate law, but the Supreme Court unanimously rejected that award.
And that's what we need to get into. Our goal is to extract the key insights into why. Why did the highest court demand respect for corporate formality, even when the alternative seems, well, deeply unfair?
Let's start with the players in the setup, because this is where the genius or maybe the chutzpah of the defendant's structure really lies.
It's quite something. On one side, you have Dewberry Engineers. They own the registered trademark. They were the victim.
And on the other, the defendant, Dewberry Group, a commercial real estate service company owned by a developer named John Dewberry.
And it's vital to understand the group's function. It wasn't the profit center. Not at all.
So what did it do?
The group provided necessary services, financial, legal, operational, marketing, to about 30 separately incorporated property-owning affiliates.
Which were also owned by the same guy, John Dewberry.
Also owned by John Dewberry.
And here's the critical accounting trick. The group charged those 30 affiliates fees for its services, but the source material confirms those fees were intentionally set at less than market rates.
Which means?
The consequence was the infringing group always reported losses. It had zero profit to disgorge. It only survived because John Dewberry would, occasionally infuse cash into it.
Meanwhile, the 30 affiliates using those cheap infringing services were racking up tens of millions in real estate profits.
Wow.
And this wasn't some innocent mistake. The district court found the group's infringement was intentional, willful, and in bad faith. It continued despite, quote, numerous red flags.
So the lower courts felt totally justified in trying to stop the entire Dewberry Group enterprise from getting away with this. They saw it as unjust enrichment.
They saw a shell game.
So the trial court and the Fourth Circuit looked past all the paperwork and just said, this is one big, willful, infringing enterprise.
Right. They said, we're going to total up the profits of the group and the affiliates to get to that massive $43 million award, all based on this idea of economic reality.
And here is where the Supreme Court came in and, applied the statutory hammer?
It really did. The unanimous ruling hinged entirely on the precise, plain meaning of the federal trademark statute, the Lanham Act. Section 1117A allows the plaintiff to recover the defendant's profits.
Okay, let's unpack that definition. Defendant's profits.
That's
the court said the term defendant means what it always means in the law.
Its usual legal meaning. The party you are actually suing.
And Dewberry Engineers only sued the group. They never sued those 30 property-owning affiliates, the ones that actually held the cash.
They never sued them. So you've sued Company A, the service provider. You can't just automatically touch the profits of Company B, C, and D, even if they share the exact same owner.
Not unless you take specific legal steps.
Which they didn't, and this is the bedrock of corporate law.
Wait, hold on. So you're telling me a proven, willful, bad actor who intentionally set up his companies to siphon off profits gets to walk away because of a paperwork technicality?
That's the frustration I think that the lower courts felt. But the Supreme Court stressed that federal statutes are built on these bedrock principles.
And the usual rule is the opposite of what the lower courts did.
The usual rule is the opposite, yes. Separately incorporated organizations are separate legal units with distinct legal rights and obligations. Full stop.
So how do you overcome that separateness? There must be a way.
There is. To legally ignore those separate corporations, you have to use the legal nuclear option. You have to pierce the corporate veil.
I've had that term. It sounds dramatic.
It is, and it's incredibly difficult to prove. You have to show the entities didn't observe basic formalities, like the owner used a single checking account for all the companies, or the affiliates didn't really hold their own board meetings.
Things that show they weren't truly separate in practice.
Exactly.
And the source material says Dewberry engineers admitted they never even tried to make that argument for veil piercing.
And that admission was fatal to their case at that stage. Because they skipped that one critical step, they basically handed the defendant a multi-million-dollar procedural win.
The demand to respect corporate formalities remains.
It remains. The Lanham Act requires defendants' profits, and the affiliates were simply not defendants.
But the plaintiff had a safety net, right? Or at least they thought they did. Once the single entity argument failed, they tried to use a specific failsafe in the Lanham Act to save that $43 million award.
Correct. They pointed to the just sum provision.
What's
It's a part of the statute that says if the recovery based on profits is inadequate or excessive, and $0 certainly seems inadequate for willful infringement, the court may, in its discretion, enter judgment for such sum as the court shall find to be just, according to the circumstances.
So the engineers argued, fine, the group's zero profit is inadequate. We should use the affiliates' $43 million as relevant evidence to figure out the group's true financial gain.
On the surface, it sounds like the exact workaround Congress intended for a tricky situation like this.
So why did the Supreme Court reject it?
Because the lower courts had ignored the statutory text from the very beginning. The Supreme Court found that they didn't do a proper two-step process.
Meaning?
They went straight to just lump summing all the profits together, which directly conflicts with the definition of defendant.
Ah, they weren't using the $43 million as evidence to calculate the group's true profit. They were just adding up the profits of 31 different companies.
Precisely. The amount itself proved the wholesale lumping. And the Supreme Court concluded that, look, while the fear that corporate formalities would insulate infringing conduct is understandable,
Sure.
that concern cannot justify ignoring the distinction between a corporate defendant and its separately incorporated affiliates. You have to follow the statute.
So the $43 million award is gone. The case gets sent back down to the lower courts. If the group still reports zero profit, does this mean the willful wrongdoer actually did profit and just got away with it?
Absolutely not. And this is where the true fight for accountability really begins now.
Okay.
The Supreme Court explicitly left several critical questions wide open for the lower courts. They didn't say whether veil piercing could still be attempted on remand or, crucially, how the just sum provision could be used legitimately.
So there's a silver lining here. If the big award is gone, what tools are left to make sure this bad actor doesn't get away with it?
This is where Justice Sotomayor's concurring opinion comes in. It's so important. She offered a strong roadmap for how courts can pursue a disgorgement award without violating those corporate formalities.
So respecting separateness does not mean courts have to be blind to clever accounting.
Exactly. She gave two powerful examples of how lower courts can correctly apply that just sum provision. The first involves analyzing a non-arm's length relationship.
So basically, John Dewberry's group was selling services to his other companies at a sweetheart discount, a huge internal subsidy, which made the infringing company always look poor.
Precisely. Sotomayor argued that if the group charged below-market rates for services, that might be seen as essentially assigning a share of the company's earnings to its affiliate in advance.
So the court could look at it through the lens of, say, tax law.
Yes, where the IRS routinely ignores those kinds of sweetheart deals between related companies.
So the court wouldn't award the affiliate's profit, but would look at what the group would have earned if they had charged a fair market rate for that infringing service.
That's it. This calculates the defendant's true profit. They're calculating the disgorgement based on the financial gain the group obscured through its accounting, not the affiliate's separate real estate profits.
And the second example. It involved those cash infusions from John Dewberry that kept the group afloat.
Right. That money may actually reflect the hidden profits the group should have earned. If the owner is constantly subsidizing the low rates the infringer is charging its affiliates, that cash can be powerful evidence of the true financial gain.
It all comes down to equity, the idea that a wrongdoer should not profit by his own wrong.
And that equity regards substance rather than form.
So, what does this all mean for you, the listener? The core lesson of the Dewberry ruling is definitive. Legal structures matter. A lot.
Even in cases of clear, willful bad faith, to get the profits of a related company, you have to use the specific legal tools for that purpose.
Like veil piercing, or applying the just sum provision correctly by focusing only on the defendant's profits. You can't just declare them all a single enterprise.
And this is a huge reminder for business owners that maintaining those corporate formalities isn't just bureaucratic overhead. It creates real legal shields that protect assets.
And if you operate affiliated entities, making sure your transactions are truly arm's length priced, as if you were dealing with a stranger, is the best firewall you can build.
It really is.
So while the Supreme Court demanded absolute respect for the legal form, they also strongly signaled that lower courts have powerful tools to uncover a defendant's true financial gain, even when it's cleverly disguised.
And that's the real challenge left on remand. The next phase of this case will show exactly how far courts can look behind a defendant's tax or accounting records,
Using those equitable principles to calculate the true profits of the infringing company.
understanding how they ultimately calculate that number, and if they succeed in forcing a disgorgement despite the low fees, is definitely something for you to keep a very close eye on.